Okay, looks like we're good to go. Thanks for your patience. Okay, we have Ms. Rackett here and Ms. Bliss here. So Ms. Bliss, you indicated you'd filed a notice of appearance just recently and that you indicated that you were asking for a continuance, correct?
That is correct, Your Honor.
Okay. Ms. Rackett, any comment related to that request?
No, there's no comment. It's fine.
Okay. All right. With the involvement of Ms. Bliss, we'll look at setting this to, let's see.
I just want this done as soon as possible.
Sure. Madam Clerk, do you know if this would be on the A or the B docket? It ends in, it's an even number. Judge Hahn in the morning, so that would be Tuesday mornings?
Your Honor,
At 9. Yes, ma'am.
could we possibly set it out for about a month because my daughter's due anytime and she's getting ready to have a baby and she's due the 12th, but she's going to go any day.
Okay.
And I would like to set it, if we're going to set it out, then set it out for a month so I can get her taken care of and the baby.
Okay. Ms. Bliss?
I have no objection to that, Your Honor. At this point, I think the only thing before the court right now is whether or not the invalidity should be approved or not. And then if not, proceeding through the dissolution process. So I don't think there's any real urgency getting this matter in 2 weeks versus a month.
Okay. So looking at roughly a month would roughly be the 19th of March, or we could look a week further beyond that, the 26th of March at 9 a.m.
26th of March would be better, please.
Okay. Ms. Bliss?
That works for me.
Okay. We'll set the matter over to March 26th, Tuesday at 9 o'clock in the morning.
I would like to have a continuance as well, if at all possible.
Could you state your name again for me, please?
Ivan Molina.
Okay, one moment. And then Summer Brody, are you on the line?
Yes, I am.
Okay, Ms. Brody's here.
I also would like a continuance to be able to properly serve the other party.
Okay.
It was
All right. So just a friendly reminder to make sure if you're not on the particular case we're discussing, make sure you're muted. So, okay, so Mr. Molina is requesting a continuance. Ms. Brody has indicated that she needs additional time to serve Mr. Molina properly. And Ms. Height is here also. Okay. Mr. Molina and also Ms. Brody, can you tell me respectively what timeframes you're looking at as far as this set over? We'll start with you, Mr. Molina.
The next is fine. I was unaware of court today, and I had just started a new job, so I'm currently on the job site right now. But I was informed by a police officer last week that I guess I had court today, and so that's why I had to. I just wanted to show up to make sure I didn't miss out, or not show up and be proper about it. But I would like a continuance, as I will be getting an attorney to represent and help with the case.
So, what amount of time? What amount of time are you proposing?
If 2 weeks from now is okay.
And have you contacted any attorneys? Because I know attorneys usually have their initial intake appointments, and it's taking weeks to get those.
Yes, so that's why I was concerned, because I actually have to meet with him at 1 o'clock today.
Okay. All right, thank you. Ms. Brody, what time frames are you suggesting?
I'm okay with that. Like 2 or 3 weeks I was thinking, so.
Okay. Is there any input from you?
No, Your Honor.
Okay.
I would like to add something. I have a couple character witnesses that are willing to come forth on my behalf as well, to testify that the stuff in my declarations are valid, and they have their own evidence to submit as well in my case. So I would like to be able to have time to get that together too.
I'll just encourage both parties to go to the Cowlitz County Superior Court website and look for local rules, and then look for local rule 88. Local rule 88 provides guidance on the number of declarations submit, the the number of pages, and also give some guidance for that as far as timing of documents. So the parties are available. We'll set this March 13 at 9 a.m. How does that look for you, Ms. Clerk?
I'm sorry, can you repeat the date?
Sure. Wednesday, March 13 at 9 a.m.
That's fine.
Okay. And Mr. Molina, March 13th at 9.
That'll be perfect.
March 19th.
Height, any concerns with that date?
13th.
Ms. Height, any concerns with that date?
No concerns, Your Honor. Thank you.
Morning. Okay, great.
To Desiree
We'll set it over to
Zimmerman,
that date.
I
Thank you.
wanted to also ask for a continuance as well.
All right, this is on Desiree Zimmerman and Christopher Zimmerman, cause number 23-3-21408.
Yeah.
Pull up my notes. Here we have Ms. Corey joining us as the guardian ad litem. This is the date set for the GAL report. That's been submitted. I've reviewed that. I'll ask if Christopher Zimmerman is on the line.
Yes, that's me, Your Honor.
Okay, Mr. Zimmerman, I see you and I can hear you. Let me ask Ms. Zimmerman the basis of your request to continue the matter.
I would like time to file a grievance.
You'd like time to file a grievance, did you say?
Yes, Your Honor.
Okay. So the grievance process is generally separate and apart from the court process, so you're free to file that grievance at any time you feel that would be appropriate. As far as the guardian ad litem report and the review and such, I think we need to review that. So do you have any other reasons why you'd like to continue the matter?
When I was looking up the process, it stated that there needed to be active court case going on in order to do that.
Yeah, the case is active. If the matter is being docketed and it's being heard, then it's an active case.
Okay.
So I think I'll deny the request to continue the matter, and we'll address it today. So I just want to make sure that both parties have received a copy of Ms. Corey's report. Mr. Zimmerman, did you receive a copy of that?
Yes, Your Honor.
Okay, and Ms. Zimmerman, did you receive a copy of it?
Yes, Your Honor.
Okay. All right. So I'll just hear briefly from Ms. Corey if you have any comments you'd like to maybe highlight or any summary you'd like to provide related to the report, or no?
No, I did want to mention though that it came to my attention after my report had been sent out to the parties that the Ms. Zimmerman had shared the report with her children, it seems, and I just found that disturbing. Otherwise, I believe my report speaks for itself. It could have easily been several hundred pages. So quite a complex case.
Okay. All right. Thank you.
May I speak, Your Honor?
Sure. Go ahead, Ms. Zimmerman.
I did not, in fact, share with my children. I went to speak with my sponsor about the outcome because myself and my support group were, with the facts that we had, prepared to advocate on my behalf of Christopher Zimmerman to make sure that no time was taken from him, and was completely caught off guard from her report, which includes lies and false information. And when I stepped out of my car to be away from my daughter, I left my phone in there, and my 13-year-old daughter could tell that I was very upset and opened up my phone to read it herself, which was still on the last page of the outcome.
Okay. Feel free if you'd like to share any additional information in response to the guardian ad litem report.
I feel like she did not properly go over all information. During our visit, I had our children present. After she was done interviewing our children, I asked for us to sit down to go over my information that I have. And she stated that after speaking with our children that she felt that was unnecessary, that she had enough information. And then after that, she went and met with Christopher Zimmerman. And during that meeting, I was asked to go pick up our children from his house so that way they could have an interview without the children present. And I feel like that was unfair to me that I was not able to show her all the evidence that I have at hand.
All right, Ms. Zimmerman, can I ask you just maybe a more specific question? The guardian ad litem makes some specific recommendations at the end of the report after detailing some of the information that she's received. Do you have any input related to the recommendations that she makes?
I do not agree with it whatsoever. I have our children most of the time anyways. As of this morning, Christopher Zimmerman messaged me if I was willing to sign off on 50-50 if he was to become the primary. I don't feel that it would benefit our children at all. One of the statements that Twyla Corey had mentioned in her report is that my daughter is failing all of her classes, and I have her most recent report card from since she's been with me, and all of her grades have gone up.
So when you said you disagree with the report entirely, do you disagree that the possible drug use of your daughter should be addressed?
I do agree with that. I have messaged Christopher Zimmerman about sitting down with him and coming up with a solution for that even.
Okay.
We were supposed to sit down this weekend and talk about a lot of things when it comes to our children, and it never happened. I've called him and messaged him several times to try to do that.
Okay. And do you agree or disagree with the recommendation to ensure that the children are not exposed to people who are actively using drugs?
I do absolutely agree to that. With that being said, Christopher Zimmerman and myself are both addicts in recovery, and our main support is at Narcotics Anonymous, full of addicts in recovery. And a lot of times part of people in recovery do relapse. When that happens with somebody in my circle, I set appropriate boundaries.
Okay. And do you agree or disagree with the recommendation that both parents should ensure that the child is properly attending school and attending to her homework?
I agree to that.
Okay. And there's a recommendation as far as a UA so that either party can request UAs?
I absolutely agree to that. I get UA'd regularly.
Okay.
Sorry.
And then there's a recommendation that both parties take a age appropriate parenting class. Do you agree with that or disagree with that?
I have taken every parenting class available and I have the certificates for that, but I absolutely am open to a refresher course, Your Honor.
Okay. And then, so it sounds like in large part, you're agreeing with the recommendations, but you disagree with the residential time split. Is that correct?
Yes, Your Honor.
Okay. All right. Thank you, Ms. Zimmerman. Let me touch base with Mr. Zimmerman if you have any input related to the recommendations made by Ms. Corey. Let's see, Mr. Zimmerman. It looks like you're muted, so if you make sure you're unmuted.
Sorry, I'm at work, so I got a company CB radio that goes on, so.
So do you have any, Ms. Zimmerman provided some feedback related to the recommendations made by the guardian ad litem. Do you have anything you'd like to comment on or?
Well, I have noticed a significant difference in Desiree's progress. It's a positive difference. It's not a negative difference. I want to be able to work out a better residential schedule than what was recommended. However, I don't want the children to have to suffer any more than they already have. I was going to speak with Desiree this weekend. However, I was really busy. My work schedule is kind of crazy. I'm on call. I work 12 hours a day, sometimes longer. So I kind of just relaxed and took the time to recuperate because I transport people for a living and my sleep is very important, and making sure that I don't, go to work tired and cause an accident, it'd be really bad. But I did reach out to her this morning, asked her if that would be something she was interested in. I didn't get a straight answer, so I just said never mind. I'm in agreement with the recommendations as far as Sarah's drug use, the schooling, pretty much everything. The only thing I'd like to do is speak more and try to get a little more residential time added for Desiree, because I feel that would be healthier for the kids, mental health wise, so to speak. Having time with both parents is a good feeling for a child to have. I know that I didn't get that option growing up as a child. But Miss Corey, I feel Miss Corey did an excellent job in doing her job. So,
Mr. Zimmerman, you mentioned that you felt it'd be helpful for the children if they had more time with their mother. What time recommendations would you have?
Well, as long as she continues the progress that she has been making, I am fully agreeable to do 50-50 custody, like 50-50 residential schedule. But like with that I said, if I see any more regression or there's people that I don't approve of that are around our children, that I'd be able to redact some of that time, because the whole point of this is whatever is better for our children. And saying to my 13-year-old daughter that she can't be around her mom from one point of time, like say every other weekend, I feel that would cause resentments towards me from my 13-year-old, which would also cause her to act out on those feelings. And so I'm trying to make sure that the decision that we all agree upon is beneficial for everybody. I just don't want people fresh out of prison or people who are still in and out of using around my children. I don't have anybody like that in my life whatsoever. I don't allow nobody to really go to my house if they aren't part of my direct family. I keep, that's my children's safe hold, so.
Okay, thank you, Mr. Zimmerman. Ms. Corey, there's a do you have any thoughts related to the suggested 50-50 time split?
So I made that decision, I guess, based on this particular moment in time, that Ms. Zimmerman is just got into an apartment. When I was over there, she had basically a chair and a bed. No beds for the children. There were her older children who aren't of age, but kind of coming and going, staying with her at times, which is not a huge deal. But I just felt that Mr. Zimmerman had the more stable environment, and especially with the daughter's attendance and grades in school, he was kind of more on top of things, meeting with the truancy officer and making a plan for moving forward for Sarah. But actually, if that were to be a graduated plan for more time for Ms. Zimmerman in the future, that was also something that I considered and that I would definitely be okay with. These parents both love their children very much, and they want what's best for them. They just have different ideas of what that is. And I believe Mr. Zimmerman is in a better position to follow through and take care of those needs at this moment in time.
98022.
Oh, thank you. All right, so I think what I want to do, I came in here and I'd read the report, and then there's there's a new proposal that's kind of been put forth by Mr. Zimmerman. Ms. Corey has commented on that. And she's made mention that maybe a graduated plan moving from maybe a more restrictive visitation time for the mother to a more expansive, maybe a 50-50 time plan, a graduated plan, maybe something that would be very good for the children. So I think, rather than making a decision here on the fly without really kind of having considered that in the context of the entire case, what I'd like to do is have the parties provide some input on what that graduated plan might look like, whether that's a plan that starts off with supervised visitation or limited visitation or weekend visitation, and then something that phases up over a period of time based on compliance with UAs or something of that nature. And so I'd like to have the parties submit something to the court to read and consider. And also Ms. Corey could chime in briefly with a potential graduated plan. I also would like an updated, Ms. Zimmerman had indicated that child's grades had improved, and so I'm hoping to get some data points related to the schooling, the attendance, and the grades with updated records. So that's what I'm thinking. I don't want to make a decision today without having considered a potential graduated plan, since both parties seem to think that's would be better in their children's interests. So I would like to give the party some time to submit that information and then come back and consider it and hear from the parties again. So I would like to set it over to the, let's see, I'm thinking 3 weeks to the 13th of March at 9:00 in the morning. That would allow the parties to draft something, hopefully this week or next, and submit it to the other side and to Ms. Corey, and then come back here on the 13th to discuss that and talk about potential revision of the parenting plan based on the input that the parties have provided. So I'll ask the Ms. Zimmerman if you have any thoughts about that.
Your Honor, first off, the statement that she just made is untrue. I just got my place and I had a couch, kitchen table, chairs, air mattresses for my children. And she asked if I needed help with anything. And I said I needed mattresses, which I have set up tomorrow to pick up. But with that being said, this is much better than what her final report stated. And I am willing to do that.
Okay, so you'll be available on March 13th and you're willing to submit some information in writing regarding a graduated potential parenting plan, and also an update on school grades and attendance, and an update on the housing situation?
Absolutely.
All right, thank you. Mr. Zimmerman?
Yes. Can you hear me?
Yes.
Okay. I am in agreement with that. However, there is a thing that the other judge had put a stipulation about my fiance not being around the children unsupervised, and then we were supposed to readdress that last time we had court. I was hoping to get that lifted, because when I'm working, the only person that I have available really that would be able to help me get my kid to school while I am at work because of my schedule would be my fiance, which my fiance is an amazing person. Miss Corey has been able to meet her. And I was hoping to be able to maybe have that lifted. I know that Miss Zimmerman does not, or Desiree does not have any issues with her whatsoever. And my children do adore her. So I was just kind of hoping that could be, that restriction be lifted, so that way I have more help while I'm working to make sure that the kids have a ride to school.
Your Honor, I also agree with what he says. I've never had an issue with her being in their life. I'm aware of her background. A lot of people that we socialize with, like I said before, are in recovery, and I know that she's in services and bettering her life, and she loves her children. And I think that Christopher could use her help. It benefit our children in being successful during his time.
Good, thank you. Ms. Corey, related to the Mr. Zimmerman's.
I have no problem with that.
Okay. All right. Looks like on December 20th, 2023, Carmi imposed that. It says father shall not leave minor children unattended with his fiancé anytime during his visit time. I'll lift that and so that she can participate and be with the children and help in the way that she can and is interested in helping. There is also a request. Okay. From December 20th, there was a request or order that Ms. Zimmerman have hair follicle test completed. Has that been done, Ms. Zimmerman?
Yes, and I passed it. That was done immediately.
Okay. And was were the results submitted? I'm not sure if I saw those.
Yes.
And Ms. Corey, did you receive a copy of those?
I did.
Okay, great. Thank you. All right, so we will return, sounds like the March 13th date at 9 o'clock works for everybody. So we'll come back on that date. We'll have input from the parties related to school attendance and grades, potential or proposed graduated parenting plans, moving up to 50-50. Then I'll draft just a brief order lifting the restriction related to the unsupervised or unattended with the fiance of Mr. Zimmerman, and we'll lift that. Okay, so any lingering questions, or just see everybody on the 13th of March?
13th of March sounds good, Your Honor.
Okay, Ms. Zimmerman?
March 13th. Thank you for your time.
Okay, great. Ms. Corey?
Thanks, Your Honor.
Okay, great. Thank you.
I'm asking for a continuance due to the fact that Heather Lucor has not provided a court-ordered hair follicle test yet to show the severity of her drug use.
I see, Ms. Lucor, your camera's on. Can you hear me okay?
Yes, I can.
Okay. And the family court investigator, Schaefer, are you on the line?
Yes, I am.
Okay, great. All right, so there was a request to continue the matter based on an indication from Mr. Denlocker that there has not been a hair follicle test submitted by Ms. Lucor. Is that your motion, Mr. Denlocker?
Yes, Your Honor.
Okay. And Ms. Lucor, any updates as far as that hair follicle test?
I had gotten it done last Wednesday. I went in yesterday and the day before trying to see if they have gotten the results in yet. They said it was still pending. I have in the meantime, which I did update Jennifer, that I did go into detox at Columbia Wellness. I did file those papers. That has my discharge paperwork, my treatment plan, my crisis plan, as well as my papers from Kelso Comprehensive Treatment Center, which is where I do the methadone at. I get dosed daily, Monday through Saturday. There with methadone, we get take homes on Sunday. So I do understand that I haven't submitted that yet. I would if I had it. I got it done I got it done a week ago, and they said that I should have the results by Friday at the latest Monday. So I don't know why they haven't got it done yet. The only reason I didn't get it done right away was because I didn't know if I needed the 5-panel or I think it was a 12 or 17 panel. And it was a $200 difference between the two. And right when we were ordered to get it done, I did not have $350 to do the larger one. So Ms. Schaefer said that she was going to try to contact you to find out which one we were supposed to get, which she had stated to me that she did not hear back. So I went ahead and did the 5-panel. And like I said, I am just waiting for those results to get in. I did know that it was going to show meth and fentanyl, honestly. So I did go through with doing detox at Columbia Wellness. I was there from midnight on the 15th until about 1 o'clock in the afternoon on the 18th. I am willing to do random UAs. I am willing to do anything that you guys ask me to do. I am set up to do outpatient at Columbia Wellness. My intake for that is on this coming Friday on the 23rd. And then following that, I will be doing 3 days a week, 3 hours a day. And then I already had my psych eval with Columbia Wellness. So originally I was going to go to Awakenings for the mental health part, but I decided to do my outpatient and mental health through Columbia Wellness. And then with the Kelso Comprehensive Treatment Center, I also see my counselor one-on-one once a week. I go to group once a week, and then I'm supposed to do one NA meeting once a week as well. So, and then I'm also getting signed up to go back to college as well. So that is my plan as of right now. The only reason I disagree on the continuance is the fact that I do know that it is going to show drugs in my system. And I went through with doing the detox and taking the steps I needed to get sober and make sure that I can, from here on out, I will be clean and there's no question about it. So I think that is it.
Okay. Thank you. And again, I just want to just touch base with Mr. Denlocker before I hear from Ms. Schaefer. Mr. Denlocker, your request to continue is based on what?
To show the court the severity of drug use. I've requested a hair follicle test every court date we've had. Our last court date, you gave Heather time to take a hair follicle test, and you also asked me to take a hair follicle test. I've submitted that. You decided to do 50-50 visitation for 1 week on, 1 week off. Heather's first week of having our daughter since November 10th, the first full week that she's had her, according to the last judgment, she did not even pick her up from school on Thursday the 8th, the 1 week that she's had her. I got a phone call from the school, and so did my sister, asking to pick up our daughter, or my daughter. It was 4:04. Emmeline gets out of school at 3:25, and I had to call Heather. Sounded like I woke her up. And this is a problem.
May I comment on that?
Yeah, one moment, please, Ms. Lucor. I want to hear from
Okay.
Ms. Schaefer. Ms. Schaefer, there's a request to continue the matter. I'm leaning towards not, and I just wanted to get your feelings.
I think like I submitted a restraining order to kind of keep the child in Mr. Denlocker's care until Ms. LaCour could get set up in counseling and start to show have a little bit of time to show that she's able to follow through with it. I don't see that a continuance would change anything for that. She has admitted that she is using, that she needs to get help. She's taking the steps to get help. So I'm not sure that continuing would change anything at this point.
Okay. All right. Thank you.
Your Honor.
I'll deny the request to continue the matter. We'll hear the matter today and make some decisions today. So I've read over the family court investigators' reports. I'm assuming that both parties, Mr. Denlocker, did you receive a copy of that?
Yes, Your Honor.
Okay. And then Ms. Lucor, did you receive a copy of the report?
Yes, Your Honor.
Okay. Ms. Schaefer, anything you'd like to add in relation to your report? I've reviewed it and I've looked at your recommendations, so I'm familiar with it.
The only thing that has changed is that Ms. LaCour did email me last night with all of the documentation from her treatment and patient, and that was not included in my report, but she has presented that with me, not with the court yet, I don't think.
And that's the same.
I did file it.
Okay.
That's the same information that she reviewed today related to the detox and being discharged there, and then having an intake appointment and then intensive outpatient planned.
Correct. Yes.
Okay. All right. Thank you. All right. Well, I'll hear just from Mr. Denlocker and then from Ms. Lucor related to the recommendations.
Your Honor, the week that Heather had her between the 2nd and the 8th, she admitted to Jennifer Schaefer that she was in fact using drugs with Emmeline in the house. I'm asking the court, Ms. Schaefer's report was somewhat faulty from the information that I had told her and in all the paperwork that I've submitted to the court. I am asking the court for sole custody of my daughter until, basically just so Heather can prove to me and the court her sobriety. I petitioned the court in November with my concerns of Heather's neglect, drug use, emotional abuse, and failure to protect a minor. After being served Ms. Schaefer's report, I am extremely concerned with Heather's admission to Ms. Schaefer that she was using fentanyl while my daughter was in the house and failed to pick up our daughter from school on Thursday, the 1 week that she had her. Heather states that using fentanyl does not affect her being a parent, and that's pretty concerning to me. Heather lied and manipulated the court, placing my daughter into her care, and the court placed our daughter into her care, knowing that she was using drugs and continued to use drugs anyway, placing my daughter in harm's way. Heather admitted to using drugs while my daughter was in her care and admitted to driving with my daughter while she was in her care on drugs. I asked that Emma not to be allowed in her care, basically, for the time being.
You have any thoughts as supervised limited visitation?
Supervised possibly, but I think that the schedule of treatment and counseling needs to go a little further, in my opinion. I want Heather to have the success that she needs. And this is affecting our child greatly. I asked Heather to provide a biweekly instead of a once a month. Before any visitation, I do want our daughter to be able to see her mom, but I want Heather to be successful in her treatment. This is not a new addiction. This has been going on prior to 2021 and has continued to get worse. She's admitted to using meth, heroin, and fentanyl. And Jennifer submitted new copies of a recent attendance record from 8/31 to 6/14, while Emma was still in Heather's care and partly pretty much in Heather's care. And it shows tardinesses and absences on it. I provided prior 8 months of school, most of it being last year, and the results were ridiculous. I have it submitted. I don't have that paperwork in front of me, but it's something like 54 tardies and just a ton of absences. I think 12 unexcused. Lots of overslept times. Since Emma has been in my care, besides the couple days I have withdrawn Emma from school for court reasons, because Heather showed up at the school immediately after court when the ex parte restraining order was lifted and tried to withdraw our daughter early from school. Our daughter was petrified to go with her. She wants to live with me and is scared to tell her mom that, because she's in fear that her mom won't love her anymore. But I truly believe that it's in Heather's best interest to get a little further with her program and sobriety before any kind of unsupervised visits.
Okay. Thank you, Mr. Denlocker.
Thank you.
Ms. Lucor and then Ms. Schaefer.
As far as the Thursday that she was in my care, I had a really, really horrible migraine. I normally would have picked Emma up. I contacted the school and asked them to put her on the bus home. They transferred me to the bus garage to talk to them about, because she hasn't taken the bus very much this year, since she had went back into care with her dad, and then it was her first week back with me. So for the most part, I was taking her, so I didn't remember which bus she was on. So they transferred me to the bus garage. I found out what bus number. I called back the school. I gave them the bus number. They did not give her the note to get on the bus to take the bus home, is what happened. And as soon as Ryan I don't know why they didn't contact me. They said they didn't have an updated phone number for me. I since then have updated my phone number with them. I don't know why they didn't have an updated phone number for me, because I gave it to them. But so as soon as Ryan contacted me saying that Emmeline was still at the school and hadn't taken the bus, I got up, I went there, I picked her up right away. It was not a lack of being a parent. It was not me forgetting about her. It was not anything like that. I went through the steps of making sure that she got on the bus to come home. So that part, I definitely disagree. It was not me just not showing up.
Can I ask a question? So
Yes.
back in January 25th, the court ordered a 50-50 split time, and it's indicated that you're using illegal, I'll call them death-defying, death-causing drug, fentanyl, while you had your child with you. Is that accurate?
The only time that I would use is in the evening when she would go to bed. I would smoke a little bit, solely because I was going through withdrawals so severely. I had tried to detox on my own multiple times, which
Okay, that's enough. Yeah, so that's it. Detoxing, I've heard, is absolutely an incredibly difficult, physically exhausting, horrible experience. And when a parent is continuing to use those types of drugs, which you don't know the mix of, you may go to sleep that night and not wake up and your child finds you. I can't endorse that at all. And I'm not going to endorse that. So I'm going to quickly reverse what was done previously. And it looks like Judge Basher gave custody to the father currently. So I'm going to follow the recommendations, but I'm going to tweak it a little bit. The primary custody of the child will be Mr. Denlocker. Ms. Lucor has taken the hair follicle test. She'll need to submit those results to the guardian ad litem and also to Mr. Denlocker and file them with the court. It looks like the evaluation has been completed. We'll anticipate that Ms. Lucor will follow through and have great fidelity in her treatment. As far as this visitation for the mother, all visitation by the mother of the child will be supervised. Either it'll be a person as recommended by Ms. Schaefer, by somebody that's approved by the father. If not, then she can pay for the supervisor, and that'll happen from Saturdays, noon to 4 p.m. That'll be supervised at all times, not to leave the county. The supervisor has the right to terminate the supervision if Ms. Lucor appears to be under the influence, and that's impacting her parenting. There'll be, before moving up to any change, there'll be a 45 days of clean time as required and manifested by UAs. Ms. Lucor will need to have at a bare minimum 2 UAs per week, and she'll have to submit those results on a regular and continuing basis to Ms. Schaefer and to Mr. Denlocker and to the court, a bare minimum of 2 per week. So once she's had 45 days of clean time, then the time can be expanded on a Saturday from 9 a.m. to 8 p.m. Once she's had 100 days of clean time, then actually 120. Fentanyl is a tough one. 120 days of clean time as manifested by UAs, then there can be an overnight starting a Friday after school to Saturday at 8 p.m. And then once there's 6 months of verified clean time through the at least 2 times per week UAs, then it can have a overnight alternating weekend schedule of Friday after school until Monday at school, and that'll be on an alternating 1st, 3rd, and 5th type arrangement. In addition, Mr. Denlocker is prohibited from using alcohol while the child is residing with him during his time. When the child's not with him, that requirement does not apply. Both parties are restrained from introducing to the child any romantic interest for a period of 9 months from the beginning of the relationship. So that'll be the court order. Any questions or clarifications?
No, thank you, Your Honor.
So will it get reevaluated, like once there is rotating weekends, like is there going to be a possibility for there to be 50-50 after that point, after the 6 months?
So recovery is obviously, it's a journey, and there's many steps each day in that journey. And the hope that Ms. Lucor, you'll be very successful in your treatment and in your recovery efforts. What the court is looking for is stability of parents. When parents are stable, children tend to be much more stable. So when a parent has exhibited stability and good parenting for an extended period of time, there's always that option for any type of motion to potentially modify a parenting plan. But the key part of this all is continued sobriety and the recovery. That is the absolute key.
Yes, sir.
Your Honor, I do have one more thing.
Go ahead.
I'm asking if I could claim MLN on my tax return for the first time.
You'll need to file a motion. We don't do those on the fly. You'll just need to file a motion, then note it up for a docket.
Okay, thank you.
All right. So, Ms. Schaefer, any additional items you need to address at this point?
No, Your Honor. Thank you.
Okay. So just so the parties are aware, I will draft that revised parenting plan and submit it. And the parties can check with the court clerk's office probably 2-3 days and get a copy of it.
Thank you, Your Honor.
Okay. All right. That'll conclude the matter for today. Thank you.
Thank you.
Yes.
Okay. Welcome, sir. And Olivia Lassiter, are you on the line? Ms. Lassiter, if you are on the line, I'm not able to hear you. Make sure you're unmuted and please state your name. All right, there's no response from Ms. Lassiter. Just double checking where we were. Last time we were here on the 31st of January. And both parties, it looks like at that point in time, Ms. Lassiter is present, Ms. Looney was not present. And Mr. DeGreat looks like he was not present at that time. I'm just reviewing the notes now. It indicated the court was giving Ms. Lassiter an opportunity to file a written response from that day, and we set it over to today's date to allow her some additional time to file a response. I don't see anything that has been filed on her behalf, and I have read Mr. DeGreat's motion for summary judgment related to parentage. I see a January 9, 2023 genetic testing report that says Mr. DeGreat is excluded as the biological father of the child. So Mr. DeGreat is asking that a disestablishment of paternity occur and that any child support obligations cease. Mr. DeGreat, does that accurately portray your motion?
Yes, Your Honor.
Okay. Give me just one moment, please. Mr. DeGreat, is there a current child support order in place?
Yeah, but it's on stay until this court is resolved.
Okay. So, and is it an administrative order through the Division of Child Support?
Yes, it's administrative.
Okay, so it's administrative. Okay. All right. So I'm granting your motion for summary judgment related to the parentage and the stopping of child support if obligation. I'll draft that order and I'll get it filed this week, and it'll be in the court file. So, roughly 2 or 3 days from the time of filing, you can get a copy of that. Do you have any questions?
When would I be able to pick that up? 2-3 days from when?
Yeah, I was purposely a bit vague, just because I'll be in court this morning. I'll be in court all this afternoon. I have a.
I get that. Take your time.
Yeah, I'm just kind of talking out loud to see what time frames. It's probably going to be Friday afternoon, probably before I get that drafted and filed. So it may be earlier, but Friday, we kind of the outer. So probably Tuesday, probably Wednesday of the next week, you can pick up a copy.
Okay, thank you so much.
Okay, all right, that'll conclude that matter. Thank you.
Thank you.
I had filed my papers, my response yesterday, and I was not able to get the papers served to Ashley. I tried last night and nobody was home. I was just curious if we could set that out a week.
Garrett Alton and Ashley Keefe. Ms. Keefe, are you on the line today?
Yeah, I am.
Okay, all right, very good. So Ms. Keefe is here and Mr. Alton is present. So there is a couple of things that I was looking at. What I show or noted up for today is Ms. Keefe's motion for contempt that was filed some time ago, and I was looking to see if Mr. Alton had been served with a copy of that motion for contempt, and I didn't see service of that. Ms. Keefe, did you serve Mr. Alton a copy of that motion?
Yeah, he was served. I don't think I turned in a proof of service though.
Oh, I apologize, Ms. Keefe. Your volume was pretty low, so I wasn't able to clearly hear you. Could you repeat that?
Oh, sorry. I did serve him, but I don't believe that I turned in a proof of service.
Okay. So at this point, without service of the documents related to the motion for contempt, and again, this is the motion related to non-information or not cooperating exchange of information and an allegation of derogatory comments about the other parent. Without service of those documents upon Mr. Alton, I think we strike the matter, and then Ms. Keefe, once you've effectuated service on Mr. Alton or Mr. Alton, once he has those documents, then you could note it up for a hearing. But until that time, I don't want to keep on readdressing this when the service hasn't been effectuated. So, and the other option is Mr. Alton can agree to service, or he's already said he can tell me that he's got copies of everything, and we could proceed. So, those are kind of the options that we have. So, Mr. Alton, have you received a copy of the motion for contempt?
Yes, I have.
Okay, and do you want to move forward today related to that, or do you want to continue it so you can submit additional information?
I was hoping to submit more information. I got served late on them, and I've been getting up for work at 1 a.m. and getting home at like 6 or 7 at night. And so I honestly kind of rushed through it, and I was hoping to have just a little bit more time if I could.
Okay. And so you have been served, and Ms. Keefe, you just need to file that declaration of service. Is that correct?
Yeah.
Again, Ms. Keefe, I apologize. The volume's pretty low, and could you repeat that?
Yeah, sorry. I don't know what is going on.
Okay. All right. So it looks like, so if service has been effectuated, and all that needs to occur is the declaration or affidavit of service to be filed, and also Mr. Alton to file a reply. I feel comfortable in setting the matter over so we can address the issues that have been presented in that motion. There's currently a motion to compel, which is noted for the 6th of March. That's 2 weeks from now. If the parties are comfortable, we could set it to that date and take care of those two matters on that same date, March 6th at 9 a.m. Mr. Alton, how does that look for you?
That should work fine.
Okay, Ms. Keefe, how does March 6th at 9 a.m. look for you?
That looks good for me.
Okay. All right. So on that date, on March 6th at 9 a.m., we will hear the motion related to contempt on the cooperating exchanging information and derogatory comments, and we'll also hear the motion to compel. So we'll see the parties on that date and time. Any questions?
No, thank you.
Mr. Alton?
Thank you, Your Honor.
Okay. All right. That'll conclude the matter. Thank you. We'll see you everybody on March 6th. Ms. Kathy?
Thank you.
And is Ms. Kathy on the line?
I don't believe so, Your Honor.
Thank you, Mr. Brewer. And Cody Dunn, are you here? Cody Dunn? Mr. Dunn, if you are on the line, I can't hear you, so please make sure you're unmuted, and then again, please state your name. Cody Dunn. All right, Mr. Dunn, there's no response. There's no one in the courtroom other than myself and the court clerk. Ms. Height is the guardian ad litem on the matter, and we're here for a pretrial hearing. So, Mr. Burrow, do you have any requests for the pretrial hearing?
No, Your Honor. I'll just note for the record, Mr. Dunn hasn't been participant in the last several hearings we've had, so it doesn't surprise me he's not here today, and we're just trying to push this through at this point. So,
all right, very good. So we do have a readiness on March 5th at 11:30 a.m. That will determine the date and time of the trial being set the week of March 11th.
and Judge, for that, I had a question. I actually have a conflict on that date. Do I have options on that, or can I have someone appear on my behalf, or what's the court's position on that?
Yeah, meaning the March 5th date?
Correct. Yeah.
Yeah, you could send a representative, but make sure your representative knows your schedule very well for that following week of March 11th. So we can pinpoint a specific day and time to have that go out.
Perfect. Thank you.
Yep, you're welcome. Ms. Height, any comments you have? If you're on the line. Okay. All right, that'll conclude the pretrial hearing. We'll see everybody and or representatives on the 5th. Is the cause. Desiree Kamba, are you on the line, please? Ms. Kamba, if you're on the line, please state your name and make sure you're unmuted. All right, not hearing a response from Ms. Kamba. No one else is in the courtroom besides myself.
I'm here.
A motion for contempt brought by Mr. Kamba, pardon me. And last time we were here, we talked about the service, and there was some certified mail, but it needs to be personal service. And I'm not sure if the personal service has been effectuated. I saw that there was efforts to do so on the 24th, 26th, the 3rd, and the 4th of February. But I didn't see that service had been accomplished. So maybe Mr. Kamba, you can give me an update.
So we tried serving her through mail. I've filled out some documents that would make that appropriate.
Okay.
And I was just waiting on a fee waiver signature for me to submit all the documents that I have. I have a very big packet.
Okay. So it sounds like what you're trying to do is you're making a motion for alternative types of service. Is that correct?
Yes.
Okay. So you're in process with that. And so then if that's approved, then you'd be able to serve through those alternative means. And then once service is completed, then we can address the motion, correct?
Yeah, but she's not in the state anymore. So, yeah.
And does she still have the child?
Yes, she does.
Okay. Have some options that you have. Sometimes those types of efforts are complicated. Some options that you might have to consult would be a website called WashingtonLawHelp.org, and then also the CLEAR hotline. The CLEAR hotline is a line staffed by attorneys in family law, and they can provide some assistance and guidance there on more complicated matters.
Okay. I believe I do have the proper documents, but like I said, I was waiting for the fee waiver for that.
Yeah, usually fee waivers, those are quickly and easily reviewed, and then once you get that back, then you could submit your request related to the service issue or the alternative service means. So I guess at this point, Mr. Kamba, with those issues pending, pending the an order allowing alternative service, do you have a request or what are your thoughts?
I just want my son back. That's all I really care about. Request that she brings him back to Washington immediately. I really, that's the only goal I have. I mean, she's done enough damage as it is. She's been in contempt for as long as I can remember now, like 5, well, not as long as I can remember, but like at least 5 months back. Right. So, she has to be stopped. She, like, I say everything in the documents that I'm going to submit. So I'm just waiting on the fee waiver for you to see all that she's done.
Okay. All right. So, so we'll let that run its course. It sounds like you'll get the fee waiver decision here shortly, and then you can submit your motion for alternative means of service for an order to serve in an alternative means. And then once you have that order, then you can make your service, you can effectuate service through those alternative means, and then you'd need to note it up on the docket for a date to address the next steps. And that's where I think those two reference or options I gave you, the WashingtonLawHelp.org website and also the CLEAR, CLEAR, CLEAR hotline, are going to be options for you to consider, just because out of state, bringing a child back, those matters tend to be a little more complicated, and without legal help, it's daunting. So those are options that you might explore.
Yes.
All right. So, Mr. Campbell, then, so we'll take care of reviewing the fee waiver, and then you'll then be submitting your motion. We'll give you a ruling on the motion for the alternative service means order. And then once that's completed, then you could note it up for a hearing, and having been informed by some of those options that I mentioned, the Washington Law Help and the CLEAR hotline. So does that give you and do you have any questions on next steps or?
Yeah, would I just like have to go to court next Wednesday after everything is submitted?
So you once you have your fee waiver decision, then you would, if you haven't already, you would submit the motion for alternative service means. Then you would have a ruling on that. Once you have a ruling on that, then you can effectuate service through that alternative means, then file the declaration or affidavit of service. Once you have that declaration of service, then that would be the time frame you'd note it up, because prior to that time, the court won't know if she's been served or not. So it wouldn't be effective use of the hearing because we wouldn't know if she'd been served or not. So once that you've effectuated service, then you'd note it up for the court for the next steps or any requested relief that you might have. Okay.
So no court next week. Next week, sorry.
No next week, because it would be premature. The motion and order for service, if that's approved, then you'd still need to effectuate that. And I don't think that's going to happen before next week. So once you have that in hand, that you've if the order is approved to serve in alternative means, then you'd need to effectuate service and then have it file an affidavit or declaration of service. And at that point, you'd note it up for the court to address the issue, because then at that point in time, the service would have been effectuated, and then that would give her an opportunity to respond. And and then we could have the hearing.
Yeah, because prior she had been served through the mail before.
We talked about that before, how with a contempt, you have to personally serve the individual unless you have an alternative service order.
Okay. I'm just hoping to see my kid before 2025.
Right. Okay. So that's kind of the thoughts I had on the different options that you might pursue.
Thank you so much, Your Honor.
All right. Thank you, Mr. Kamba. Zach Bissig, are you on the line today?
Yes, I am, Your Honor.
Welcome, sir. Megan Gibson, are you on the line today?
Yes, Your Honor.
Welcome to you. And I see Ms. Kell is on the line.
Good morning, Your Honor.
Morning. I see that this is a motion brought by Ms. Kell related to moving the date of the report out to March 19th based on inpatient status of Mr. Bissig, or was an inpatient, and looking to move it to that date. Anything further, Ms. Kell?
Not at this time. I understand Mr. Bissig came out of inpatient treatment just a couple of days ago, so I'd like to offer congratulations to him on that.
Great, thanks. Okay, and Mr. Bissig, any concerns related to the GAL's motion to extend the date to file a report?
No, I totally agree with her.
Okay, Ms. Gibson, do you have any concerns?
Yes, Your Honor, I have a couple of concerns which I have voiced with Mrs. Kale through our communication. I have no problems giving Zach a chance to prove that he can be the parent that I know that he can be for our children. My only concerns is I understand that this process is a very long process, but we've been going through this with this parenting plan for 4 months now. Mr. Bissig has not been complying to everything like he's supposed to be, i.e. the guardian ad litem investigation, the hair follicle test. He didn't send the car seat picture like he was supposed to until weeks later, staying sober. Like, I've done everything asked of me. He has not been doing what has been asked of him these last 4 months. The only reason he went to treatment is because he got in trouble again and was court ordered because of his DUI to go. I would have no hesitations with this if it was him choosing to go on his own to better himself, not only for himself, but for our children. But that wasn't the case.
So thank you, Ms. Gibson. So there's a motion brought by Ms. Kell to move the due date to March 19th. You've specified some concerns related to non-compliance. If you have concerns related to non-compliance, any party, for that matter, if they have concerns regarding compliance of a court order, one of the remedies that a party can pursue is a motion for contempt for failure to follow a court order. So that's an option if you have concerns related to any court order. As far as your the motion to move it to March 19th, it sounds like you are concerned that it may be taking too long and the like. Other than that, do you have any additional concerns about setting the hearing to March 19th?
I'm having to take time off of work to be here every time we have court, and I'm the only one supporting our children currently. So I'm just saying that, like, I have no problems moving it. I just feel that it's very unfair to me and my children who, like, I've been doing everything asked of me. I'm the one that sits here with my kids when they're crying because they want their dad, but he's not making the appropriate choices. But yet we're giving him yet another chance after he has repeatedly not done what he's supposed to be doing.
I'll grant the motion. We'll set the matter to March 19th at 9 o'clock in the morning. Each party will have an opportunity to review that, and we'll review it on that date. And if there's pressing concerns, we can make some adjustments. Any questions?
Yeah, I just want to state the fact that I was not court ordered to go to inpatient. I did not get in trouble. I put myself there.
Particular points. Both of you, those are important things that you're sharing. They are important for today's purposes. There was a motion before the court related to a hearing date. I've made that decision, so we can address those issues when we come back on March 19th. Thank you.
Thank you. I
Haley
appreciate
Lawrence, are you on the line?
I'm here.
Okay, welcome to you, Ms. Lawrence. And Luis Kozar, are you on the line?
Yes, I am here, Your Honor.
Okay, welcome to you, Mr. Kozar. And I see that Ms. Turnbull is present.
Yes, Your Honor.
All right, good morning. And this is a matter in which it looks like the guardian ad litem submitted her report. Looks like it was dated 7th of February. I'll check with Ms. Lawrence. Did you receive a copy of that report?
I did. And I filed a response to it.
All right. Mr. Kozar, did you receive a copy? I apologize.
Yes, I did receive a copy. I just haven't had the chance to file mine or look at it very much because I've just been working a lot of overtime the past few weeks, so I've been getting home pretty late every day.
Okay. All right. So, and I do see the 2-page document that Ms. Lawrence filed in response. So let me touch base with the parties. There's some recommendations that the guardian ad litem, Ms. Turnbull, makes related to her investigation. And it sounds like Ms. Lawrence has some input on those recommendations, and it sounds like Mr. Kozar has not filed anything in response. Mr. Kozar, are you planning on filing something?
Yes, I am planning to. I just haven't had the time at all to even make it in the time frame before the clerk's office even closes. Like I said, I've been getting home pretty late most days, so I do plan on filing here soon. It's just I've just been a little bit behind, I guess, unfortunately, because of work.
What's your status with the domestic violence treatment program?
I started my 36-week program. I actually had my first session was Monday. It's when I'm doing them every Monday from 5 to 6:30.
Okay. Ms. Turnbull, is from your vantage point, do you, as far as the timing of this hearing, it was scheduled for today. Do you have any strong input one way or the other, whether we go forward with the hearing today or whether some time is given to for Mr. Kozar to respond in writing?
I'm not opposed to postponing it. My concern is he has had significant amount of time to respond to other issues like the domestic violence, filing the domestic violence, filing the completion of the parenting plan that's been asked of him over the last number of months, and neither of those have been done. So,
okay, thanks. I think what we'll do, we'll move forward with the hearing today. Both parties have had an opportunity to review it. Ms. Lawrence has filed something in writing. Mr. Kozar is free to respond here verbally. I'll make mention, Ms. Lawrence did make some proposals in that she feels like Mr. Kozar is doing pretty well and wants to phase up to additional phase in the parenting plan, and that she's recommending that the start time be addressed because 3 p.m. both parties are working, and then there's a distance between the two of them, and then she's also making an overnight recommendation. So with that kind of on the table, I want to hear Ms. Turnbull if you have any thoughts related to that, to those proposals.
I know both parties would like that very much. My concern is that based on the history of this couple, if we don't hold some boundaries for them, that they're not going to hold them for themselves.
Okay, thank you. All right, I'll hear from and just Ms. Turnbull, do you have any other points related to your report that you would like to highlight? So I've reviewed it.
If you've reviewed it, not at this time.
Okay, all right, thank you. Okay, Mr. Kozar, any comments related to the guardian ad litem's recommendation?
I would just, I think I'm a pretty good dad when I spend the time I have been spending around my son, and Haley's been nice enough to let me spend a little more than what I am, than just the supervised visits. So it's been nice getting to spend actual quality time with my son. And I feel like when I do spend time with him, we're always having fun. There's always smiles and laughs. Like there's never really terrible times when I'm with my son, I would ever say. I always enjoy just being there for him, being, a good father that he needs to have in his life, that figure. So I do agree with Haley too, that I would like to have a lot more time and overnights with my son and actually be able to spend quality time with him again instead of just, a couple hours, which just flies by, which kind of hurts me and my son when he has to leave me both. So I just would like to be able to spend more time with him.
Thank you, Mr. Kozar. Ms. Lawrence?
Yeah, I feel like as long as he continues doing the classes and stuff, if we were able to move to the phase 2 so that he could have more time with him. And if he wasn't in compliance, we could always move back. But I feel like he will do pretty good at following what he's supposed to be doing.
Ms. Turnbull, any specific feedback on the recommendation of skipping phase 1 of the supervised time to the unsupervised time on Sundays, other than the importance of boundaries that you emphasized earlier?
As long as he's showing compliance of being enrolled in the domestic violence program, which I have not yet seen, I would be okay with that.
Okay. All right.
Can I just add something? Sorry.
Sure.
I'm not entirely sure why I get under my communication, I haven't told you, but they were supposed to send you a couple of emails. I put down you as my guardian ad litem and your email and all that contact information. So I'm not sure why they haven't sent you anything yet, but I'll reach out to them later today. So hopefully you're better kept in the loop as well, Amy. So that way you know that I am participating in the programs and whatnot every Monday too. So
Thank you.
All right, thank you. Okay, so I'm not hearing any strong objections to the guardian ad litem's recommendation. Ms. Lawrence, I just want to touch base with you. There's a recommendation that you involve yourself in individual counseling. Do you have any concerns related to that?
Is that the therapy that she's talking about?
I believe so, yes.
Yeah, I don't mind doing that. It's just I don't have a lot of free time when I go to work and then I get off work. I pick up both of my kids. So if I'm able to do like an at-home one, then that would be fine. But I don't have additional childcare to go and do that.
And then is there any concerns of either party, from either party, related to the recommendation of completing the Love and Logic class?
No.
Okay, Mr. Kozar?
No.
There's also a recommendation as far as some limiting factors of domestic violence, use of conflict, and withholding of child that are recommended to be imposed upon Mr. Kozar. Any concerns related to that, Mr. Kozar?
No, Your Honor.
Okay, Ms. Lawrence?
No, as long as he continues doing the class, I think that it should be okay.
Okay. As far as the start time in phase 4, Ms. Lawrence, you raised that issue as being a challenge because of time when both of you get off work. What time do you get off work?
So I get off at 4 and I'm not quite sure what time he gets off. I know it's a little bit later usually, so you'd have to ask him on that one.
Okay. Mr. Kozar?
I usually get home. It depends on my day because my office is out in Beaverton. So I can usually end up with customers or just kind of scheduled anywhere south of there or even north of Olympia. So I guess it kind of depends on my day, but usually about anywhere from the earliest is like 4 to around like 8 is usually when I get home. So kind of later in the day.
Okay. All right. Well, I'll adopt the recommendations of the guardian ad litem as to the limitations that I mentioned before: domestic violence, the conflict, and withholding. I will require both parties to enroll and complete the Love and Logic class, and that should be done within 60 days. I'll just put a little notation there. And then as far as the phase, at this point in time, it sounds like the parties are comfortable skipping the phase 1, conditioned upon Mr. Kozar providing that compliance information of his domestic violence treatment, which it sounds like he does have, but just needs to get filed. And so once that's been received by all parties, meaning Ms. Turnbull and Ms. Lawrence, and filed with the court, then the Sunday noon to 4 p.m. supervised and the midweek video can move to the phase 2, which would be Sunday noon to 4 unsupervised and a midweek video visit. I'm just going to make that notation here. And then once there's been 90 days of compliance with that domestic violence, then the Sunday noon to 4 would be banded 9 a.m. to 6 p.m. With a midweek video visit. As far as the then phase 4 would be the completion of the domestic violence program, and then that would revert to an alternative weekend, 3rd and the 5th weekends, Friday at 5 p.m. to Sunday at 5 p.m. And with a midweek visit or a visit during the off weeks, the 2nd and 4th week, Wednesday, kind of a default 3 to 3 to 7 p.m. And I recognize that the times may need to be adjusted based on work schedules, but the idea is basically up to 4 hours on that midweek visit. And there's no disagreement from Ms. Lawrence as far as engaging in therapy/counseling and doing that. So, I'll draft that order up and then I'll submit it to the parties. And they should have that done by Friday at the latest of this week, maybe sooner. So any questions on the court's ruling and such? Well, we'll start with Ms. Turnbull and then we'll go to Ms. Lawrence and Mr. Kozar.
No questions, Your Honor. Thank you.
All right, Ms. Lawrence?
My only question is, so do we have another court date, and then during that court date, we discuss if he's showed the proof that he's doing the classes, and then we do the unsupervised, or how do we know when that date starts?
Yeah, good point. So no need for a specific court hearing. So once there's been the 60 days of, pardon me, so once there's been the 90 days of compliance, and that's where Mr. Kozar would need to file a monthly report with the court and submit a copy to Ms. Turnbull and submit a copy to Ms. Lawrence, so we know what his status is as far as compliance. So once that's been submitted and all parties can see that he's compliant for those 90 days, then the full day Sunday can begin. So no need to come to court. The parties can police themselves and see once that, so that'll be conditioned upon Mr. Kozar submitting that documentation and showing that compliance, and the parties can look at it.
Okay, so did we move to phase 2 today then, or?
Upon a showing that he's compliant with his domestic violence treatment. Yes.
Okay, thank you.
So, yeah, make sure, Mr. Kozar, you get that submitted to the court, copy to Ms. Turnbull, copy to Ms. Lawrence, and once that's submitted to all parties and it shows that compliance, then it's at phase 2. If not, it remains supervised visitations Sunday at 12 noon to 4 p.m. and a midweek video visit. Okay. All right. So hearing no additional comments, I think that concludes the matter for today. Thank you. And that'll conclude the hearing.
Thank you, Your Honor.
Thank you.